Should an employer trigger FMLA leave without an employee request? Imagine you're at work and suddenly an employee's absence looks like it could be covered by the Family and Medical Leave Act. Do you wait for them to ask or act first? This is a common question in employment law. Under the Family and Medical Leave Act, employers are required to designate leave as FMLA leave when it qualifies, even if the employee hasn't asked for it specifically. Once the employer has enough information to see that the leave is for a serious health condition or a family member's health issue, they must notify the employee of their FMLA rights. This means the employer can't wait for the employee to request FMLA leave or refuse to classify the leave as FMLA just because the employee hasn't asked. Employers have a duty to act promptly once they know or should know that the leave could be FMLA qualifying. This can happen through the employee's statements, medical certifications, or other facts. For example, if an employee mentions they have a serious health condition and provide a medical certification, the employer should designate the leave as FMLA. They are also allowed to request medical certification to support this designation. It's important to understand that employees are usually expected to give notice about their need for leave in advance, typically 30 days if the leave is foreseeable. But even if the employee doesn't give notice, the employer's obligation to designate the leave as FMLA does not depend on a formal request. If the employer has enough information, they must act. Employers can require employees to use paid leave at the same time as FMLA leave, but this doesn't change the employer's duty to designate the leave as FMLA. The leave entitlement of up to 12 weeks or up to 26 weeks for military caregiver leave runs concurrently with paid leave if the employee or employer substitutes paid leave. In practice, this means employers should have procedures in place to identify potential FMLA situations. Once they know or should know that the leave could be for a qualifying reason, they need to notify the employee about their rights and responsibilities. This includes providing eligibility notices and necessary paperwork, even if the employee hasn't specifically asked for FMLA leave. From a legal standpoint, acting quickly to designate qualifying leave as FMLA protects employee rights and helps employers stay compliant with federal laws. It prevents accidental loss of protections because of employee oversight or lack of knowledge. In short, employers should trigger and designate FMLA leave without waiting for an employee to ask, as long as they have enough information to determine the leave qualifies. This approach ensures both the employee's rights are protected and the employer stays within legal boundaries.